day, child.
Before we begin, let me remind everybody that there are reporting restrictions in place, and the court has ordered that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the child or any member of his family in connection with these proceedings. Yes, Mr. Setwright.
May it please my lady and my lords, in this appeal I appear on behalf of the appellant father, together with my learned friends Mr. Edward Deverex and Mr. Michael Gratian, and my learned friends Mr. James Turner, Queen's Counsel, and Ms. Finola Moore appear on behalf of the respondent mother. There are three interveners. They've been given permission to make written submissions, but two of them have had the courtesy to appear, or to attend, I should say, by their counsel, and so with my lady's leave, I can introduce Mr. Tirtha Gupta, Queen's Counsel, and Ms. Jacqueline Renton on behalf of the Reunite International Child Abduction Centre, and my learned friends Mr. David Williams, Queen's Counsel, and Mr. Michael Edwards on behalf of the Air Centre. They've prudently sat not in this row, but should they be needed or called upon, here they are. The third intervener, there are written submissions prepared by Mr. Harrison, Queen's Counsel, and Mr. George from the International Centre for Family Law Policy.
Well, could I say at the outset how very grateful we are for all three interventions. Although there's a certain amount of repetition, inevitably, between their submissions, they have each of them added something of value to the information before us. So we're grateful to you all.
And my lady, and my lords, it will be the case that in my opening submissions this morning, I will take the court to some of the submissions that have been made by the interveners, where these appear to us to be of interest and where we may seek to place reliance upon them. So we have found them helpful in some measure. My lady and my lords, because the court has the statement of facts and issues and the detailed written cases, it may not be necessary or helpful for me to provide a detailed opening of this matter. And so, unless there is a different view from the bench, I won't take up time.
I'm not getting one. I think you can assume that we have, as a minimum, read all the written submissions and the judgments in the courts below. And so, some of us will have also read the evidence.
Because this is a public hearing, I should simply say that this case concerns the party's only child, an 8-year-old boy, and it concerns the factual situation by which the mother brought the child from Morocco, where the child had been living, to England without the father's consent, in circumstances which Mr. Justice Roderick Wood, at the first instance hearing, found were in effect an abduction. But not an abduction to which the 1980 Hague Convention on International Child Abduction effectively applies, because that convention is not in force currently between Morocco and England. The father made an application to the Moroccan court, and the Moroccan court didn't give him residential custody, but he does have parental responsibility.
Yes, and he also has the benefit of an extensive, what we would call a contact order.
Which includes substantial periods of staying contact.
Does it? I thought not. I thought it was...
Holidays, isn't it?
Holiday
yes, but it's on condition that he doesn't stay overnight.
It includes, because it includes substantial periods of holiday contact, the difficulty had been that there was no female person available in the father's household. The essential difficulty following that order in terms of contact, because I can tell my lady and my lords that there has been no face-to-face contact, is that the father, who has medical problems, is unable to travel from Morocco to England, and no arrangements have been made for the child to travel from England to Morocco. There followed an application for a return to Morocco of a kind which hitherto has been commonly made in such cases. And we say that this is, I hesitate to use the loaded word paradigm, it's a typical case, because the majority of child abduction cases in the experience of the English court have been cases where a primary carer parent, a de facto or de jure primary carer parent, has removed a child or retained a child internationally, contrary to the rights, typically rights under the parental responsibility, of the other non-primary carer parent. And in those circumstances, both under the 1980 Convention and, if appropriate, in the inherent jurisdiction, English judges contemplate a return under the 1980 Convention in accordance with the specific criteria of that convention. Under the inherent jurisdiction, on the basis of welfare, as defined by the House of Lords in the leading case of Re J. Mr. Justice Roderick Wood heard the case in that way, and having determined that it was in the best welfare interests of the child S to be returned to Morocco, he made that order. So far as Mr. Justice Roderick Wood was concerned, there was an habitual residence in Morocco. The order was made and appealed to the Court of Appeal, and it's fair to say that in the early stages, the appeal that was mounted did not embrace the sophisticated jurisdictional arguments that are now before this court.
They're not that sophisticated, Mr. Setright. They're pretty simple. Right or wrong. As to the convention, it's fascinating. The convention was indeed mentioned before Mr. Justice Roderick Wood, but Article 11 didn't feature.
Let me rephrase it, my lady. The stark jurisdictional difficulty which has engendered sophisticated arguments, which now appears...
Oh, well, you can call them sophisticated, Mr. Setright. I couldn't possibly comment.
Not yet, my lady. Which has engendered arguments which now appear before this court. And without, I hope, treading on any toes in this row, it was principally Lady Justice Black who identified the particular problem. And if I identify the stark problem in a nutshell before moving to how we say it ought to be solved, it is this. The jurisdictional landscape has been altered by the advent, first, of the Brussels IIa regulation, and second, by the advent of the 1996 Convention. The regulation and the convention are not always easy bedfellows, because tantalizingly, although it may be argued that in some respects they come from a similar root, that is ROOT, they are expressed differently, including in respect of the provisions which Lady Justice Black had to consider. But when considering jurisdiction in an international case, conventionally, and I believe that there's a commonality of approach between Mr. Turner and myself to this extent, one should look first at the regulation to see what the jurisdiction is. One then looks, if appropriate, at the 1996 Convention. One then turns, if appropriate, to the Family Law Act, as amended. Ultimately, there may be various routes to have recourse to an English domestic jurisdiction, but that domestic jurisdiction is defined and constrained by the regulation and the convention. Having found, I choose my words more carefully, on the basis that the child was habitually resident in Morocco, Lady Justice Black looked to see what the routes to jurisdiction would be. And by reference to Articles 7 and 11 of the 1996 Convention, she came to two conclusions. And I think I'm addressing them in reverse order, but nevertheless. One was that the inherent jurisdiction, which was the jurisdiction that had been placed before Mr. Justice Roderick Wood and exercised by him, had not been available. The other was that on a proper application of Article 11 and on the specific characteristics of the case that was before her, there was not an access to the urgent measures under Article 11 by which, in some circumstances, Lady Justice Black conceded, return orders might, in appropriate cases, be made. And so the question before this court is, as my lady has put it, was her ladyship right or was she wrong in her interpretation of Article 11 and on the restriction which that, in this case, says Lady Justice Black, places on the ability of the English court to return this child.
Or to make any other order in respect of the child.
Well, yes,
because
sir.
as the centre very helpfully points out, the purpose of assuming jurisdiction in cases of urgency, whatever that may mean, is to give the court here, where the child is, jurisdiction to make orders for the protection of the child. That doesn't necessarily have to be a return order.
Just so. And so, although no doubt Mr. Turner will say that there's quite a narrow focus to Lady Justice Black's judgment in its essentials, we say, as do the interveners, that there are wide-ranging implications for a decision of principle, which it appears has been made. My lady, as to the positions of the parties, again, as the court has read, there's no need for me to do more, I hope, than to provide the baldest summary. That in the grounds of appeal, which are on electronic page 31 in the core bundle, there are summarised the approach of the appellant. Wrong to find, wrong in its interpretation and its approach and application of Article 11, and wrong in particular to find that this case was not a case of urgency. And then there is a third point, which may not occupy, subject to the court, a very great portion of my oral submissions today.
That's relief.
which relates to priority. The finding that it was in the court's best interests, in the child's best interests, to return the consideration of all possible avenues for the exercise of jurisdiction. But I should mention that Articles 61 and 62 of the Brussels 2A regulation impose a priority. It's a priority which appears in other contexts as between European regulation and Hague Convention. It says that there is a priority for the regulation over the convention. And there are arguments which have been dealt with by us in our written case, have been dealt with by the interveners to some extent, and very shortly, right at the end of his written case by Mr. Turner, as to that aspect. But that is not front line in the submissions that we are making to the court today. Mr. Turner's position, in a nutshell, is that Lady Justice Black was right. She was right to take a restrictive view of Article 11, to treat it as an article that controls an exception to jurisdiction, and therefore she was right to take the limited approach that she did, in particular in the context of what Mr. Justice Roderick Wood had said about welfare considerations. And Mr. Turner would not forgive me if I did not also say to the court that he would wish everyone to be reminded that because of the nature of the decision that she reached, that is to say, a decision on jurisdiction which brought the process to an end, virtually the entirety of Mr. Turner's appeal, or Miss Turner's and Miss Moore's appeal, went unresolved. And therefore, if we prevail, or if our appeal finds favour with my lady and my lords, Mr. Turner will be saying, well, it will need to be sent back to the Court of Appeal so that the process can be completed. My lady and my lords, that was all I intended to say before launching into additional oral submissions to supplement our written case. Unless, of course, there are any other areas that the court feels that I have missed and should deal with.
Well, I'm struggling to find much difference between grounds 1 and 2.
Ground 2 is a specific expression of ground.
Yes, but what else do you complain about in her interpretation of
well, may I come?
You can come to that, can't you, Mr. Sedgwick?
I think I'd better. Our written case starts at MS 187. What I'm not going to do in deference to the time available is to plod through it, but I hope to go in relative terms, in a logical manner through it. I'm so sorry, I gave the court the wrong reference, MS 150. 187 is the father's. Mr. Justice, as the mother's, I should say, Mr. Justice Roderick Wood's judgment appears from MS 320 onwards, and there are some passages in that judgment that it is helpful to my case to draw attention to, because they provide, we say, the bedrock for his decision, and they also provide an indication of the strength of the welfare position, which caused him to say that there should be a return of this child. If I look at electronic page 331, at paragraph 37, there's a finding by Mr. Justice Roderick Wood that the father and S were habitually resident prior to the 14th of September, and that there was a wrongful removal from the jurisdiction on that date. I say this as a comment. This was a non-convention abduction. Mr. Justice Roderick Wood does use the language of the convention. There's some authority about that, not least, I think, in Re J. But there's no criticism from either side of him for doing that, and it is indeed potentially helpful that those particular technical elements have been isolated, because they also have traction with a consideration of a regulation and convention position. Paragraph 40, the father has under Moroccan laws parental responsibility for his son. The mother's denied him the right to exercise it by bringing S here. So rights of custody and breached. So in contrast to numbers of inherent jurisdiction child abduction cases, all the elements of a Hague Child Abduction Convention case are present, as found by Mr. Justice Roderick Wood. And the immediate position is set out by Mr. Justice Roderick Wood at 41. She's also prevented in any real way the father exercising any face-to-face contact since September of last year. She speaks of plans to visit Morocco and letting the father have contact there in the summer, but she's made no such provision, and in any event claims she can't afford to make the journey. And as Mr. Justice Roderick Wood put it, she cannot afford to have it both ways. So if one looks at, as I must begin to do, the urgency of the situation and the welfare element, there is Mr. Justice Roderick Wood identifying a current situation which is unresolved. Further on, at 43, the mother raises no real welfare concerns about S returning to Morocco, nor equally does S in his interview with the Kafkas officer. So again, this case is set apart from those numerous convention and non-convention cases in which it is asserted by the removing parent that there is some compelling reason why the child should not be returned to the other jurisdiction. So we say that taken all together, again, I'll avoid using the word paradigm, but this was a classic, full-strength abduction case. What about delay? Well, the 1980 Hague Convention, and I don't need to take, unless the court wishes, my lady and my lords, to it, has an element of time about it. The remedy is one which, if pursued within 12 months of the wrongful removal or retention, avoids any argument of settlement in the new jurisdiction under Article 12, and therefore allows for only limited welfare-based defences to a return, those defences being that a return would place the child at grave risk of physical or psychological harm, or otherwise in an intolerable situation. In this case, this is a child who expressed no difficulty about returning to Morocco, who the mother had said, albeit she makes no practical arrangements, she would return for holidays to Morocco, and who had undoubtedly lived in, gone to school in, was habitually resident in Morocco. Matters of consent were raised by the mother. That's another defence under the 1980 Convention. Mr. Justice Roderick Wood made a finding that there was nothing in the nature of consent. And so we say that that bedrock means that this case, which did come on within the Article 12 months under the 1980 Convention, is a case which has all the characteristics of what one might call an ordinarily compelling child abduction case.
Could I just understand, Mr. Settright, for my own purposes, why it is that you're telling us so much about the 1980 Convention which doesn't apply? Is it that you say that its principles were capable of informing the decision that Mr. Justice Wood had to make whether to exercise the power to order a return or not?
Partly, my lord, it is that. Partly, it's a reflection on some of the submissions made by the interveners, which I will draw to the court's attention in due course, particularly of Reunite, about the need for a commonality of approach in abduction cases. Partly, it is because there is a clear linkage between the Brussels 2A regulation and the 1980 Convention, and partly because there is a similar route, again, ROOT, in the 1996. But I absolutely remind myself that this was not a 1980 Convention case. But Mr. Justice Roderick Wood, who it might be inferred knows the difference between the two as one of the most experienced judges of the division, nevertheless, on a welfare basis, in a way that would have been quite unnecessary for him to do in that positive way in a 1980 Convention case, found that there was a welfare need for a return. That, I say, is an additional and important factor. In a 1980 case, the court would not need to find that it was in the child's welfare interest to return. Simply, there wouldn't be a finding that it was contrary to the welfare interest. But here are positive findings.
Well, he was applying Re J, wasn't he?
He was.
Nobody having told him that he shouldn't.
Nobody raised the point in a way that turned out to be effective. I'm being very careful.
Well put, yes.
Not to tread on toes. If I move on from there, what the father did initially was to go to the Moroccan court. What the Moroccan court has done is to make a generous contact order. Contact took place on a regular and frequent basis between the father and S in Morocco. And there are findings on that also in the judgment of Mr. Justice Roderick Wood. And also in the judgment of Lady Justice Black. If I take my Lady and my Lords to MS 321, at paragraph 4, 5 lines from the bottom. On any view, he, the father, certainly had all of the summer holidays with us in 2012 and 2013, and regular and frequent indirect contact, and furthermore, as apparently agreed, contact from time to time facilitated by members of the maternal family.
Mr. Settright, can you just clear up a confusion that I myself overlooked, but Lady Hale raised early this morning? Was the summer holiday contact also subject to the proviso that S should sleep at the grandparents overnight?
Yes. No, in our understanding, that was not subject to the proviso, it was stay in contact.
I see.
And where do I find that? Yes, but where is that? That's appendix. If one looks at appendix part 2, MS 514, at paragraph 13, looking at the, about halfway down the paragraph, it's not correct that S spent the entire summer holiday with his father. S has informed me that during the summer holidays his father had planned to spend time together. However, he was unable to look after S properly. He therefore left S with his family members for approximately 1 week. S has also told me that he did not know who these family members were. By necessary interpretation of that, it looks as if, for periods, the child was, the mother would say notionally, in the father's residential care. Give me the reference. Yes, this paragraph. Yeah. But
What it actually says at page 671, which is the judgment of the Moroccan court
yes,
on the 12th of July 2012,
yeah,
it says, furthermore, the divorced wife shall allow her ex-husband to visit his child on Sundays and holidays, starting from 9 a.m. until 5 p.m. of the same day, under the condition that the child must spend the night at his mother's residence. That appears to be what the order says.
It does.
But it appears that the facts
yes.
involved the child going to his father's home and spending time there during the holidays.
That was why I said what I did.
Yes.
Lady, I don't know if it would help at this stage. I can certainly help on that, but if it would help now, I can do it.
No, it would not, Mr.
I'll leave it
Turner.
till
I
later,
think
I'm
we'll
sorry.
stay at our proper place. Yep.
And there it was in the judgment of Mr. Justice Roderick Wood, MS 321, paragraph 4. He certainly had all of the summer holidays with S in 2012 and 13. And furthermore, as is apparently agreed, contact facilitated by the family. So there it is, whether or not it was overnight by virtue of the order, there's an impression that there was overnight contact. But one way or another, the contact was frequent. And there plainly was an established and important relationship.
Well, some of the interesting evidence is in paragraph 8 of the Kafkas report.
Yes, quite so.
And no doubt there is other.
Yeah.
That's page 5, line 4.
Yes. And if one looks at Mrs. Odd's, on that very page, if I can take the court to it, at paragraph 8, when asked what the child remembered and which country he wanted to talk about first, he said, Morocco. There I have my daddy. He attended school in Morocco, spent all his school holidays with the father in Fez. Again, that we say is consistent with residential contact. S told me that the father had a housekeeper who came sometimes to assist with cleaning and cooking, did a little bit of cooking, only a few friends at school in Taza. Father used the washing machine, and there are other matters. Paragraph 9, S refers to when I went swimming in Madyak, when he went on holidays with the father in Agadir. Again, if he went on holidays with the father in Agadir, that is highly suggestive that substantial periods were spent. He said when he lived in Morocco, his mother used to come to see him, and he didn't know that his mother was taking him back to the UK. He said the mother told him that they were going back to England, and he was happy because I wanted to live here. And he said this was because he wanted to live with his mother. So it's a classic situation. But in answer to the question of the court, there is evidence which is strongly suggestive, and Mr. Justice Roderick Wood plainly found it persuasive, that there was not only substantial contact, but overnight contact.
Very well, thank you.
With his father. So if I continue, if I look with the court at MS page 330, there Mr. Justice Roderick Wood deals with considerations in the Moroccan court. Perhaps I should start on 329. One of the matters that the judge was dealing with was the Moroccan Family Code. And at paragraph 31, the statute of the 3rd of February 2004 doesn't mention in any of its articles the relocation to another country of the child, as it's put, wanted for custody of the parent. The custodian does not lose custody over the child if she moves permanently to a different town in Morocco. Some members of this court may very well be familiar with the Sharia-based law systems, some of which are different in degree to others, and the extent to which primary carer mothers are allowed the facility to move either within or externally to a particular jurisdiction. If such lawsuit to relocate the child to another country is brought, the family court, in giving its decision, may consider the child's best interests and the ability of the non-custodian parent to visit the child, parents' visitation rights. So from the point of view of the Moroccan court, contact rights are important, as of course they are from the point of view of an English court when dealing with matters in the domestic jurisdiction, the Children Act, the ordinary domestic jurisdiction, or indeed in the inherent jurisdiction, if this can be reached, in dealing with a child abduction. We have made a summary in our written case from MS 159 to 161 of what we say are the important findings, but I have now covered the background. But my lords and my lady and my lords, the most important finding perhaps in terms of the current situation, which we summarize at MS 160, was that the mother had effectively prevented the father, had prevented S from having any direct contact at all. And Mr. Justice Roderick Wood described it as a fatal blow to direct contact with the father. So Mr. Justice Roderick Wood's finding was essentially this: we say that absent a return of S, the gap in contact would not be made up. There didn't indeed seem, and perhaps that's an area of commonality between Mr. Justice Roderick Wood and Lady Justice Black, there didn't seem to be any other obvious way of remedying the situation than to provide for a return. If that is right, then we say it feeds in to the question of urgency in the current situation as it must have appeared to Mr. Justice Roderick Wood and as it should have appeared to Lady Justice Black. So the impact of the decision of the Court of Appeal, we say, is that the English court is prevented from implementing an order which was designed to protect S, because it protects him from the continued deficit in contact. It's intended to accord with his best welfare interest. But the decision is the court can't do it. The Court of Appeal reaffirms that Morocco has a substantive jurisdiction. And so, as my lady put it, there isn't another route, and not just in these circumstances, but in all sorts of other circumstances that one could postulate for the Article 11 jurisdiction to be available to a court for protective purposes. And so it leaves S and the father without any recourse to any available remedy, other than technically by further application to the Moroccan court, which is conjectural, or by the possibility, which is where the residual submissions on Article 61 and 62 come in, that there may be a move of habitual residence from Morocco to England, in which case arguably a different analysis of jurisdiction would need to be performed, there being different rules under the 1996 Convention and the Brussels IIa regulation as to movements of jurisdiction.
Can I just understand?
Yes.
You said that the route of further application of the Moroccan court was conjectural. Do you mean conjectural whether he may make such an application, or conjectural what the outcome would be?
Whether he could
Yeah.
is the first question. We're not able to help the court with that. We have the Moroccan statute. The Moroccan statute doesn't on its face appear to provide for the ability to make return orders, simpliciter. Though the Moroccans have ratified the 1980 Convention.
Did anybody seek to put in expert evidence on that issue?
Well, there was expert evidence which was controversial before Mr. Justice Roderick Wood.
Directed to that issue?
Not specifically directed to that.
Right.
But researches have been attempted, and also by the International Centre, which has indicated in its written submissions to the court that it's been unable to discern whether or not there is a jurisdiction in Morocco to make return orders. We are in the same position.
There's certainly a jurisdiction in the Moroccan court, isn't there, Mr. Setright, to allow a parent like a mother to relocate abroad. If there's that, it would be odd if where a mother hasn't taken advantage of applying for that order and goes wrongfully, there is no jurisdiction to order her return.
In answer to my Lord's first question, yes, there is a relocation jurisdiction. I'm not sure that I would concede that it would necessarily be odd if there wasn't the ability to make a return order. It would be odd in our eyes. But the Moroccan jurisdiction is an autonomous jurisdiction. It doesn't have the same root.
How much can one divine from Morocco's accession to the 1980 Convention, Mr. Setright? this court, the English courts have ample power, don't they, to call for the return of a child who's been removed from this country.
We always have had, under,
Yes,
dare I say it, probably our inherent jurisdiction.
that may be the origin.
So-
What I'm getting at is anything you can divine from the accession to the 1980 convention.
There isn't, my lord, for this reason, that the convention provides a particular route to do it. One of the considerations in the early experience of the 1980 convention in this country and also in Australia was that sometimes parties would feel it necessary or appropriate before making their application through the central authority to obtain a return order from an English judge. Wasn't necessary, and because it tended to be the case that that would be a without notice application, it wasn't likely to be of much value either. And so we would say that an accession to the 1980 doesn't necessarily indicate that there is or even should be a power. It's an alternative route, potentially. But I mustn't speculate. If I return to the submissions.
What can we get from Article 7 of the 1980? You're going to come to this, I expect, Mr. Setright.
Yes.
All right, well, don't do it now.
Article 7 of the 1996
No.
of the Moroccan Civil
the
Code.
1980 convention. 724.
Well, let me look at that now.
Central authorities shall take appropriate measures to initiate or facilitate the institution of judicial or administrative proceedings with a view to obtaining the return of the child. That's the abducted child. 7. Is that any help or not?
It is, but it's a question of which country those proceedings are in. I'm sorry, I'm being almost interrogatory. I apologise. The central authorities shall cooperate,
Yes.
and
I see, yes, I follow, yeah.
so in other
I
words,
mean, it might be aimed at the place to which the child has been taken.
one of the fundamental tenets of making that convention work is that when there is, let us suppose that it operated between Morocco and England, that there was a route by which proceedings could be swiftly started in England, and that is the key.
Yes, thank you.
If I can go back just a few minutes.
Yes, of course.
You mentioned the possibility that the child's habitual residence might have altered at some point since he was brought to this country. Are you going to be addressing the implications of that at some stage?
Yes, sir. Towards the end of submissions, and hopefully I won't be spending too long on it. Time is already running. The plain fact is, we say, again, ploughing my furrow of welfare, necessity and urgency, that there's a clear breach of the Moroccan contact order. There's an inevitable breach. It is impossible to construe the Moroccan order as one which in the practical circumstances can be effective in England, because the father cannot come to England. And in the international...
Where's the evidence that the father can't come to England? I think it would be good to be pointed in that direction.
Well,
We know that he has a disability which makes travel difficult, although obviously
Yes.
not impossible given the number of times he's relocated in his professional life.
What I could take the court to the evidence, but I could take my lady and my lords to the judgment of Mr. Justice Roderick Wood. But let me see if I can find some evidence. If I look with my lady and my lords at turning first to Mr. Justice Roderick Wood, 322, paragraph 5. father suffered from polio as a child, has a moderate mobility problem, regular and frequent international travel would be difficult for him on that ground alone, but he also lacks the means to do so. And he also may, as a professor at a Moroccan university, require the consent of his employers in taking such leave. And so that was the impression or the finding which Mr. Justice Roderick Wood formed, and so perhaps that feeds on to the observations at the top of MS 323, which follows on from that. There is no provision in the order for the mother to unilaterally decide to move to other countries with the child. When she did so, it dealt an almost fatal blow to any form of direct contact with the father. And where does it say he's unwell? Yes. The evidence is at Appendix Part 2, MS 520. And it's fairly short. I would have great difficulty attending court hearings. This is paragraph 3. I would require permission from my employer, which is very difficult to obtain even in exceptional circumstances. The only time I could obtain such permission with ease is during the course of the summer holiday. That, coupled with my reduced mobility, makes international travel challenging. And then over to MS 526. I am a disabled man. This is paragraph 24. I had polio as a baby, and that has resulted in reduced mobility, which makes any international travel difficult and near impossible without assistance. But my disability would not affect my being able to see S and take care of him. I did so for 2 months during our travels last summer.
Does it follow that S hasn't seen the maternal grandparents for 2 years? Or might they have come over here in the interim, Mr. Setright? Or wasn't that explored?
Might they come over? We don't believe that he has seen any members of the paternal family. So we adopt the submissions of the International Centre, and they're to be found, and I won't take the court to them. I'll simply give the reference at MS 283, paragraph 49, of the impact of research, which shows that international child abduction has a significant and deleterious effect on the child's relationship with the left-behind parent that can be long-lasting. If I look with my lady and my lords at what Lady Justice Black says, that is at MS 310. And this is the core, for these purposes, of the Court of Appeal's judgment in paragraphs 71 to 75. Lady Justice Black says, I'm prepared to accept that there may be cases in which a return order is urgent and necessary. So far, so good, my lady and my lords. I'm also prepared to accept, at least for the sake of argument, that it is possible to make an order such as a return order, the effects of which are less easily reversed than some other possible protective measures, notwithstanding the provisions of Article 11.2, which speak of the measures lapsing when the contracting state with jurisdiction takes the measures required by that situation. we will make submissions to the court on the arcane subject of the sale of perishable goods, which is something that is specifically contemplated as being authorised. And the sale of perishable goods is obviously something that is likely to be irreversible.
Well, Article 11.2 is dealing with orders lapsing. It doesn't mean that you can't make an order unless it's an order which could theoretically lapse.
No. With respect, my lord, precisely so. Then one goes to paragraph 72. What I cannot accept is that this particular case was a case of urgency for the purposes of Article 11. Well, we say, for the reasons which we set out, that it was. The Lagarde report suggested in relation to Article 11 that a situation of urgency may exist. And I pause to say, well, the Lagarde report is useful and we refer, as do others, to it. But there is a dearth of authority on Article 11, although not a dearth of authority, as my lady and my lords will hear, on Article 20 of the Brussels 2A regulation. The Lagarde report suggested in relation to Article 11 that a situation of urgency might exist where if remedial action were only sought through the normal channels of Articles 5 and 10, there might be irreparable harm to the child. And then Lady Justice Black elides Article 11 with Article 20 and the approach under the former with the approach of the Court of Justice to the latter in the case of Detacek and Segulia. The view of the court in Detacek was very similar. See paragraph 42 of the decision quoted above, and there it is at the top of the page. Since Article 21 of Regulation of Brussels 2A authorises a court which does not have jurisdiction as to the substance to take exceptionally a provisional measure concerning parental responsibility, it must be considered that the concept of urgency in that provision relates both to the situation of the child and to the impossibility in practice of bringing the application concerning parental responsibility before the court with jurisdiction as to the substance. Now, we will make submissions to my lady and my lords distinguishing the Article 20 measure from the Article 11. They're under different instruments. They are expressed differently. They operate differently. But that is the passage which Lady Justice Black informed herself about. But let us see what she says about it. Returning to paragraph 72, middle of the paragraph, but in this case, approximately 6 months had passed before the father took action in our courts, and over a year had passed by the time of Mr. Justice Roderick Wood's decision. The father showed by his prior application to the Moroccan courts that a speedy application to the courts with jurisdiction under Article 5, that's an habitual residence-based jurisdiction, was entirely possible. Well, indeed, so it was. An application was possible, but there wasn't evidence as to what remedy he could obtain. And there's been no explanation as to why he did not apply in Morocco for a return order rather than a change of residence. Pausing for a moment there, that has very great implications if that is a requirement that becomes a jurisdictional rule in terms of the approach to Article 11. It would also, we say, become an area of difficulty, though I don't have to take this on, with regard to the operation of Article 20. If I take an example, if a child is in this country and there is not a jurisdiction, which is something that occurs commonly, every judge at first instance in a case with an international element is required, and there have been judgments from the Court of Appeal, notably by the President, ramming this point forcefully home. Judges are required to examine jurisdiction at the outset of the proceedings. If they do not have a jurisdiction, that is a substantive jurisdiction, that does not, of course, mean that there is an extant set of proceedings in the other country. Very often, there is not. In public law proceedings, where commonly this exercise is performed, there is almost always not a commonality of party, in that the public authority which makes the English application for a care order is not an authority with any standing in the other country. And if there are no proceedings in that country, well, who would start such proceedings? It is manifestly unlikely that the parents in those circumstances would be so obliging as to start proceedings, even if there was a route to them, as there might well be.
Do we have some examples, I haven't checked this, in the authorities before us, of the 96 Convention operating in the context of public law proceedings?
No.
Because that has been something that has struck me throughout
I was
consideration
too
of this
quick to
case.
say, no, there is one, and let me take to it in a moment.
Don't let me take you off your stride,
No,
Mr.
but-
Setright. I just want to ask the question,
but-
get an answer in due course.
I can, but it's an important consideration. Lady Justice Black was referred from the bar to the fact that Article 20 is used in those circumstances to secure the physical return of the child from this country to another jurisdiction. We were not able to provide her with authorities, that is, reported cases. The reason is probably obvious, because it has not been the subject of dispute. If there is no substantive jurisdiction, an obvious protective measure, if a child is stranded, jurisdictionless in this country, is to return under Article 20, or for that matter, under Article 11. But Lady Justice Black, in her own researches, found, and it's at MS 309, paragraph 64, an example in the relatively old case of Re S, a trafficking case from Romania, in which Mr. Justice Charles said that an application of Articles 17 and 20 founded a return. So if I take another example, suppose that there was an application to enforce contact in this country, and contact, in order to take place, required the presence of the child in the other country. What power would the court have physically to return the child? It could say, we enforce the contact order, but in order to make provision to make that enforcement effective, if the child had, in circumstances as in those in this case, to ensure the return of the child, it would have to exercise a jurisdiction so to do.
You're contemplating a contact order made in the home state?
Yes.
And an application to enforce it here?
Yes.
You're saying that return may be an element of that?
Yes.
Yes.
And under both Brussels 2A and the 1996, those are possibilities. If Lady Justice Black's approach was followed, then the court would have to look in all those cases to whether or not steps had been taken to secure a return order, specifically a return order in the other jurisdiction, as opposed to reliance simply, for example, on the contact order. the difficulty that that would cause in a case where there was a want of jurisdiction and no proceedings at all in the state of habitual residence is quite obvious.
Well, the trouble is, isn't it, Mr. Setright, that on any view, the 96 Convention confers, as it were, primary jurisdiction
Yes.
on what I've been calling the home state. I hope that isn't too obscure.
We know exactly what
There's a supplemental jurisdiction under Article 11. And the problem throughout seems to me, at least, to be at what point can you properly exercise the supplemental jurisdiction? If you were enforcing a contact order, it might be said that you ought to start by getting out of the home state an order which addressed the question of whether the child's return was required or not. Because sometimes, as events move on, contact orders have to be adjusted, don't they?
It might, my lord.
But doesn't that go to the question of not whether you've got jurisdiction, but how you exercise it having it?
Yes,
Precisely.
it probably does, yes.
Yes. And we say that necessity, urgency, which can't be divorced in a children's case from best interests, in particular when one looks, and we have adverted to this and so have the interveners, at the purpose of the 1996 Convention, which is the protection of children.
No, I've got that. You're going to come at some stage, presumably, to what courts should do if you're right.
Yes.
Assuming they have jurisdiction, as my lady says.
Yes.
The question is whether you exercise it or not.
Yes.
What kind of inquiries are incumbent on an English court of what can properly be done at home, or are no such inquiries normally required? Anyway, you'll come to
yes,
that, I'm sure.
But I'm tempted to say, my lord, that if one has findings of the kind that were made by Mr. Justice Roderick Wood, which are comprehensive findings about the situation of this particular child, then one looks at welfare in that context, and that one construes urgency and necessity purposively in the light of those findings. That, we say, is what Lady Justice Black regrettably did not do in this case. And so, have you got that authority? May I, before I forget, where is it? Well, I will come back to that. If I revert to the page MS 310 and the approach of Lady Justice Black, looking at the middle of paragraph 72. In this case, approximately 6 months passed before the father took action, over a year passed by the time of Mr. Justice Roderick Wood's decision. He could make a speedy application to Morocco. I can see, Her Ladyship says, that in some cases the passage of time will make a measure of protection more urgent rather than less, but the facts would be very different from these in my view. What is potentially harmful to S here is not his living arrangements, but the fact that he's not keeping up his relationship with his father by direct contact. It's very important that be remedied, but I cannot accept that there is here a need for urgent protection, such as would entitle the court to act under Article 11. And we make the submission there that, with great respect to her, Lady Justice Black is simply wrong in her approach to the factual matrix and to the findings which Mr. Justice Roderick Wood had made. And it's a way of addressing my Lord Hughes' point to say that if necessity and urgency are to be viewed in the context of an individual case and the findings about that case, and although Mr. Turner might seek to chip away at those findings in his other grounds of appeal. When Lady Justice Black was considering what to do, there they were full strength. That was the decision that she should have come to. That is to say that it was urgent and necessary.
I mean, you don't disagree that what is potentially harmful here is, among other things, not keeping up a relationship with your client. But as I understand it, Mr. Setright, you say that there are other potential harms here. There is an issue between the parents about where this child should live, in which country, and it's been on foot now for a year, and it's got to be resolved. Would that be an aspect of potential harm?
It would, and it's a classic of international jurisdictional cases that such questions should be decided in the court of the country of habitual residence.
Do we need to look at what's meant by measures of protection? Because we tend to use the word protection when we're thinking very specifically about harm, possibly in the public law sense. But maybe this convention is looking at protection in a much wider way. And I wonder whether that slightly colours the approach.
We would suggest that it is indeed, that is to say the 1996 is, and it's looking very much more broadly. But my lady, perhaps what I can do is just to complete looking at the next two paragraphs, and then turn, because my time is rapidly ebbing away, to some other matters. So far, says Lady Justice Black, I've established that Brussels 2A didn't apply and that 96 didn't confer jurisdiction. Was there any other basis? The instinctive reaction of the English lawyer in these circumstances is to reach for the inherent jurisdiction, but in my view it cannot assist. The whole purpose of the 1996 is to determine, as between contracting states, which is the appropriate state with jurisdiction. And that would be defeated if a contracting state was able to assume jurisdiction by virtue of a domestic rule. And Her Ladyship cites ANA in the Supreme Court. And so the inherent jurisdiction was ruled out. But then at 75, Her Ladyship says, in order not to sow the seeds of confusion for future cases, I should make clear I'm not suggesting that the courts here can never have recourse to the inherent jurisdiction. There are two elements, both a basis for exercising jurisdiction and a source of the power to make orders. Well, my lady and my lords, that is perhaps of little assistance, with great respect, but it highlights one of the areas of distinction between Articles 20, B2A, and 11. Article 20 of the European regulation doesn't provide a jurisdiction. What it does do is to allow a recourse to remedies available in the domestic jurisdiction. And those remedies, the exercise of which is based on urgency and necessity, but also on physical presence, those measures will lapse when the child exits the jurisdiction. Article 11 is different. Article 11 does create a jurisdiction. And as my Lord Wilson observed, Article 11 orders run after, potentially, the child leaves the jurisdiction. That's why one can make Article 11 measures to protect a child ancillary to a return order in a 1980 Hague Convention case, thus replacing or mirroring the undertakings which had been commonly used to that purpose. And we say that's a distinction between the two. And when Her Ladyship refers to the source of power to make orders, well, yes, in all sorts of ways, recourse could be had to the inherent jurisdiction, provided the Article 11 test was met. It's circular.
If the Article 11 test is met, well, then there is jurisdiction to make any of the orders under Section 2(1)(a) of the
Exactly.
of the Family Law Act.
But if it's not,
met, there's no jurisdiction.
which is why I said, unfortunately, that is not that observation is not particularly helpful. It's a circle, but it's a circle that leads, with respect, nowhere. Have we got that case? And to answer my lady's question, the 1996 the 1996 public law case is to be found at Authorities Volume 10.
Sorry?
Authorities Volume 10, MS 3363. It was a case in the geographical scope of the 1996 convention.
Tab 78, is it? Mr. Justice Cobb's case.
Mr. Justice Cobb,
Yeah.
NA. My lords, my lady and my lords, I'm going to have to speed up if I'm going to make sufficient progress to let Mr. Turner speak when I had agreed that he should. So, if I may.
Can I just ask,
yes,
before you speed up, can I just ask, was Lady Justice Black referred to the handbook?
She was.
She was.
She was.
You'll know that the handbook envisages Article 11 being used in cases of wrongful abduction.
Yes.
But it's always considering the situation where there's also jurisdiction under the 1980 Convention and envisages the return order being made under the 1980 Convention and Article 11 of the 96 Convention being used to make ancillary orders.
That's absolutely right. Yes.
Is there any logic in? Is there any logical reason why Article 11, in the absence of jurisdiction under the 1980 Convention, couldn't be used to make the return order itself?
None whatever. And in that sense, I think Lady Justice Black appears to have recognised that it can be used to make return orders in a proper case.
Yeah.
She doesn't think this was a proper case.
Yeah, well, her thinking seems to be, if I've understood it correctly, that the starting point is that jurisdiction lies in Morocco.
Yes.
And therefore, the need for urgency would arise if proceedings in the Moroccan court were liable to take so long that, in the interim, the English court had to protect the position of a child. For example, by making a contact order. But we don't know anything. We don't seem to know anything about whether proceedings are possible in Morocco or what sort of timescale they might require.
And nor did Her Ladyship. But what she was faced with was the evidence, insofar as findings are evidence, about the welfare needs of this particular specific child in the context of an abduction. And the delay, which she rightly adverts to, was a delay which was A, within 1980 Hague Convention limits, and B, not regarded by Mr. Justice Roderick Wood, when dealing with this matter in the inherent jurisdiction, as militating against a return, a summary return, in the inherent jurisdiction.
Mr. Setright, I know you're worried about time.
I am.
Please forgive me, just briefly. We've got, I think, the 2011 handbook at 21. There is a suggestion, I think Mr. Harrison makes it, that the 2014 handbook is interesting, in particular with a footnote. Yes. And do we have the 2014 handbook? If not, I know it's terribly bulky, let it not be copied, but could we have at least one version of it at some stage after this hearing? Or have we got it?
We have got it. And let me seek to take your...
Well, in due course, give us the reference.
Yes. Yes. If my lords, my lady and my lords read on, then the 2014 follows on from the earlier one.
It's all in 21?
Yes, it is. So MS 1343 onwards.
1343.
Yes, please.
Thank you.
Thank you.
Got it. Yeah, 2014.
Shall I deal with those two words? Debtor check and the revisions. May I have a moment to see what I can cut? Article, the debtor check and the revision. Debtor check and the revision. Anything else? What are measures of protection? Yeah. Yeah. I promised that I would deal with what are measures of protection. If I look with the court at Authorities tab 4, MS 732, that is the 1996 convention. Article 1, the objects of the convention are to determine the state whose authorities have jurisdiction to take measures directed to the protection of the person or property of the child. Measures are the term for all orders made in the exercise of powers conferred by the 1996. The Lagarde report, which is at which is at Authorities tab 20, MS 1178. Thank you. At paragraph 68, so MS 1178, Authorities volume 2, deals with jurisdiction in case of urgency, and it deals with property. It says that, as well as the person of the child, jurisdiction to take in cases of urgency the necessary measures of protection. One can look at the examples here. The Convention doesn't define the notion of urgency, and it said that it's present where the situation, if remedial action were only sought through the normal channels, might bring about, not would bring about, my lady and my lords, but might bring about irreparable harm for the child. The situation of urgency justifies a derogation from the normal rule and ought for this reason to be construed rather quickly. But we say, perhaps construed rather strictly, but construed with the overarching principle that the best interests of the child, and there I would have to revert to the Convention itself, Authorities Volume 1, MS 732, where the preamble above Article 1 says, confirming that the best interests of the child are to be a primary consideration, and desiring to establish common provisions to this effect, that is, on the protection of children, taking into account the United Nations Convention on the Rights of the Child of the 20th of November 1989. And the court will have seen, and I don't have the time to take my lady and my lords through it in detail, the reliance placed particularly by the Air Centre on the United Nations Convention on the Rights of the Child. That's been a convention that's been considered in various cases in this jurisdiction. But here, this court is assisted by the fact that it is specifically a root, again, ROOT, of the intendment of this instrument to establish provisions taking into account that convention. Going back, if I may, to 1178 and the Lagarde report, if, and unfortunately it's not numbered within paragraph 68, but looking at the last block of text in that paragraph, beginning with the words, if this jurisdiction had not been provided, the delays which would have been caused by the obligation to bring a request before the authorities of the state of the child's habitual residence might compromise the protection of the interests of the child. This concurrent jurisdiction will have occasion to be exercised, for example, if it's necessary to secure representation for a child who must undergo surgery, or yet it is necessary to make a rapid sale of perishable goods. But that can't possibly, we say, be an exhaustive description of what the provisions of Article 11 apply to. The last words under paragraph 1 in the Lagarde report are, the Commission deliberately abstained from setting out what measures might be taken on the basis of urgency in the application of Article 11. This is indeed a functional concept, the urgency dictating in each situation the necessary measures. So what measures of protection there should be and what measures of protection can potentially come under Article 11 is not something where there is a tight, restrictive definition, we say, which binds this court any more than it bound Lady Justice Black. This is the 2014. And if I can take my lady and my lords on, logically, to the current practice guide, and in particular to Authorities Volume 3, MS page 1368. And the passage is... Yeah. And if one starts at the top of the page, and this is a rather lengthy attempt to answer the question, which matters, that lengthy by me, not by the handbook, I should say, which matters are covered by the 1996 Convention? The Convention sets down rules in respect of measures directed to the protection of the person or the property of the child. The Convention doesn't provide a precise definition as to what these measures of protection may include. Then there are examples, and again it said, this is not intended to be an exhausted list. And so then there is an approach which is a different approach, and we say it's a helpful approach to our case. The attribution, exercise, termination or restriction of parental responsibility, as well as its delegation. That is the widest possible exposition of decisions made in respect of a child. And the makers of this report say, middle of the comment at 316, the description of the term in the Convention is purposely broad. It covers at the same time responsibility concerning the person of the child, his or her property, legal representation, whatever name is given to the legal institution in question. Rights and responsibilities, they can be to do, 317, with, dare I say it, almost anything. Custody, education, healthcare, determination of the residence of the child, the supervision of the child's person or relationships. And then powers has more to do specifically with the representation of the child, usually undertaken by parents, but maybe by third parties. That doesn't engage here. And then, interestingly, at 319, the terminology used for these concepts varies among states, with patria potestas as well as parental responsibility being examples. There one finds, following on some examples, we say that the examples, which are numerous, don't in any sense rule out, for example, the making of a return if dictated by the child's best interests, in order to secure a parent-child relationship in a timely manner. And, my lady and my lords, we know that in our domestic jurisdiction, delay is a material consideration. Plainly, delay on these authorities and these guidance publications is perfectly capable of being a consideration. The use of the word urgency implies it. May I turn to look at a particular point which we have been anxious to deal with and which we did not deal with in our written case in detail, which is the distinction between Article 20 of the regulation and Article 11 of the Convention. And as I promised at the outset of these submissions, the distinguishing, or an attempt to distinguish, debtor check, relied upon by Lady Justice Black to some extent, and relied upon by my learned friend Mr. Turner, quite understandably, if I may say so. I would comment this, though, that on a careful analysis of what Lady Justice Black says about debtor check, it's not clear that she regards that as having been an absolute block in making the decision that she took in this particular case.
I find it difficult to see that debtor check helps very much, because debtor check was the completely opposite situation from the one with which we're concerned,
Yes,
wasn't it?
Indeed.
Yeah. So in other words, in debtor check, you've got the country of habitual residence making one order, and then time slides by, and the country to whom the child's been taken says, oh, well, we think gradual change of events is enough to cause us to alter the first court's order.
Yes.
And the court says, well, that progressive change isn't a situation of urgency. We're concerned with a situation where the issue is whether the child should be returned very promptly in support of the order of the court having substantive jurisdiction.
The English judge having decided that a return is necessary to support that order, in effect.
Yeah.
Yes. Well, with respect, yes, my lord. I'm very much in the court's hands as to how much time I take up dealing with debtor check now. But perhaps I can restrict myself, because I will have at least a brief opportunity to reply to Mr. Turner.
You'll have half an hour.
Yes, that's a brief opportunity. Knowing Mr. Turner, as I do, that can I summarise our position in that case? That the aims and objectives of the two instruments, it's Brussels 2A and the 1996, are different. The one is a European instrument intended to achieve the aims of the European Union, and so certain assumptions must be made about the court processes in that close and ever closer union, which are not made necessarily in the 1996. And examples are the well-known case of Peruca and Valles Perez, which is at authorities tab 31. I'm not going to take the court to it. at MS 1861 and 1864. And yes, and we say that that approach doesn't apply, shouldn't apply in relation to Article 11. If one strips away debtor check and the use to which Lady Justice Black puts it, then there's a wide open field of interpretation, informed by the handbook, informed by Lagarde, but undoubtedly with no, we say, prescriptive restriction or demand for exceptionality, to use a word that the Court of Appeal sometimes uses, that the difficulty of requiring litigation or a demonstration of the impossibility of litigation in another non-European state as a condition for reliance on Article 11 is that it may involve an impossibility or it may involve a lengthy expiration, and it hasn't been possible to determine the point with any reliability in this particular case. And Lady Justice Black, in her judgment, seemed to suggest that there wouldn't be many cases of this kind. As my lady and my lords will have seen, Reunite says otherwise, that Moroccan cases are not infrequent. And
So it hasn't been possible to answer the question, but has anybody asked whether Morocco makes orders calling for the return of its children?
attempts have been made to discover it. No expert has been instructed.
Nobody's asked them,
I'm so sorry.
nobody's asked them by way of judicial interchange. Nobody's asked the Moroccan authority.
There was no judicial expiration. As your lordship will have seen, the point was not one which came...
No, I understand how it may have happened. I just wanted to know whether anything has actually... No one's asked, have they?
No one has asked in a formal way.
You can ask the UK Central Authority to get to the bottom of it, can't you, Mr. Setright, under Article 30?
Yeah. Yeah. May I have a moment? When did we ask? Yeah. Yeah. No. But that wasn't this question. No, it wasn't. It shows you the difficulties. What Mr. Deverex and Mr. Deverex, unlike my learned friend Mr. Gratian and myself, appeared in the court at first instance. He indicated that during the hearing before Mr. Justice Roderick Wood, questions were attempted through the Central Authority. Not questions about return orders, but questions about Moroccan law.
Yes.
And the result, it's in the appendix part 2, and perhaps I should take my lady and my lords to it. It's the very last page, MS 692.
Yeah.
And it's a response from a very experienced person at the Central Authority to the father's solicitors. And I'm grateful to Mr. Deverex for pointing this out, because it does assist in a particular way. And it says, I have not received an acknowledgement from Morocco which would explain any timescales. As I explained in my initial email, it took around 4 months to receive a reply to a similar request I made. I did not receive an acknowledgement in that case either. And so perhaps it's not entirely surprising. First, that there was an attempt to have recourse to an expert in the proceedings before Mr. Justice Roderick Wood. And second, that it didn't appear remotely practicable to pursue that otherwise obvious, with great respect, line of inquiry. It also indicates that there is with this particular country, and I don't wish to criticise Morocco at all, there is a substantial element of delay in obtaining information to deal with the point which Miss Lady Justice Black indicated she didn't have an answer to. So I hope that helps. I can't take it further than that. I recognise on one level it's an unsatisfactory situation, but there was an attempt made to explore the route, and it was an abjectly unsuccessful one.
You may not know the answer to this, but you probably do. There is, of course, a network of judges under the 1980 Hague Convention. In fact, I believe I'm a member of it. I can't think why, but I am.
I think my lady is.
Yes. But am I right in thinking there is no such network in relation to those 96 convention parties who are not... Well, Morocco is and is not a party to the 1980 convention.
It is. We are not in liaison with it.
Yes.
I think I know the answer, but I'm slightly
Maybe you would like, if you can check it over the short adjournment, that
Can
would
I?
be very helpful. And if possible, agree it with Mr. Turner.
Thank you very much. So reverting to my attempt to distinguish between Article 11 and Article 20, and we say that, as I've said, it is likely to be more difficult because of the range of states involved to require litigation in the state of habitual residence as a precondition or a review of it. But the effect of the two articles is also different. I've already indicated Article 20 is not a ground of jurisdiction. It falls outside the jurisdictional scheme as an exception. Article 11, based on presence also, but it creates a lengthier, longer-lasting jurisdiction. Article 20, as considered in debtor check, was intended to enhance protection for abducted children by preventing parents from relying on it to legitimise a wrongful removal or retention. And as my Lord said, that was an entirely different context. That was an attempt to hijack, in effect, the effects of the decisions of the court of the state of habitual residence, exporting that definition, that restrictive definition, to Article 11 would, we say, have the effect of reducing the protection for abducted children. And this is an absolute exemplar, because here is a judge who said there is a welfare need for this child to be returned. We say that it's far from clear that if faced with a case of this kind, again, the point made by my Lord, that if faced with a case on these facts, the CJU would make the same restrictive observations as it did in debtor check. Nothing in Article 11 requires steps to be taken in the Convention state of habitual residence. So debtor check and Lady Justice Black, insofar as they've said so, have added a gloss. And we say that particularly where the gloss appears to militate against welfare as found, the court should be very cautious in the ordinary approach to interpreting international conventions, in A, construing it other than purposively, and B, providing a definition and a gloss. Where do I find the Article 50? Thank you very much. And finally, on the 1996, and it may only be a convention straw in the wind. If I take my Lady and my Lords to Authorities, Volume 1, page 7, 842. There is Article 50. There are always surprises in all conventions and instruments of this kind. And here is Article 50. This convention shall not affect the application of the Convention of 25th of October 1980, the Child Abduction Convention. So far, so good, and with respect, so obvious. As between parties to both conventions, well, England and Morocco at the moment, sadly, are not. Nothing, however, precludes provisions of this convention from being invoked, and I do rely on the word nothing, from being invoked for the purposes of obtaining the return of a child who has been wrongfully removed or retained, or of organising access rights. Well, goodness, my lady and my lords, we say that's this case.
There seems to be a suggestion, Mr. Setright, that the second sentence means nothing, however, precludes provisions of this convention from being invoked as between parties to both conventions for the purposes of ... Now, that may not be the end of your point.
No.
But do you agree that it should be read that way?
I'm not sure, my lord, that I agree that there is a logic to it being read that way, because if it was read that way, it might not add very much, because a wrongful removal or retention is, of course, a 1980 convention concept. And so it's surplusage. Nor
Well,
does
it
it...
isn't, is it? It's saying it's precisely because it's a 1980 concept that it looks as if it means wrongful removal or retention under that convention. But you can also use the present convention, which may give you additional power. For example, it gives you, very importantly, gives you direct enforcement in State B of an order made in State A.
But, my lord, the power to return is a power which doesn't require the exercise of a power under the 1996, because that power is provided by the 1980.
If you had got an order from the home state calling for return, it's a jolly sight quicker, isn't it, simply to enforce it in the country to which the child's been taken, rather than starting separate 1980 convention proceedings.
That is certainly right, but by the same token, it wouldn't require Article 50 to make that point. Equally, this convention can often be used to provide measures of protection supplementary to a return. But that's not what it says here. But, my lords,
so are you suggesting that? Forget my point. Are you suggesting that the second sentence would really envisage an order for the purposes of obtaining a return being made under Article 11 above?
Well, I do, with all due deference, suggest it might.
Yes.
I don't want to place too much stress on Article 50, but I do say it's there. And what it does do is to emphasise the application of this 1996 convention to secure the return of children who've been wrongfully removed or retained, or to organise access rights. And nothing precludes the provisions of this convention from being invoked for that purpose. Does that include Article 11? Or is it something which is restricted to the operation of the 1980? Well, I'm not going to take up time over it, but the thrust of it, the overall intendment of the convention, is plainly to secure the protection of children in their best interests, including with the consideration of returning them and supporting the exercise of rights of access. My Lady and my Lords, one point that, by way of information, we can provide to the court, and we've given the document to Mr. Turner this morning, relates to a process which is well known, which is currently being undertaken, which is a review of the Brussels 2A regulation. And that's a well advanced process. And as part of that process, consideration is being given to the revision of Article 20.
Thank you.
And it's my final point on debtor check and the elision. Again, I don't want to place too much emphasis on it, but obviously it's our duty to bring the court up to date. This document comes from the Directorate General of Internal Policies at the European Parliament, and its author is Hans van Loon, who will be known to some of my lady and my lords, the, dare I say, eminent former Secretary General of the Hague Conference. And the passages that I need to take the court to are modest. If I take my lady and my lords to internal page 17, there is the proposal for a new article on protective measures. And the observations of Hans van Loon may be of some interest and assistance in the task which this court has to undertake. And first it deals under 3.1.3 with safe harbour and mirror orders and the contrast between what is available under Article 11 and what is, dare I say it, not available under Article 20, where there is, as it's put, as the CJU, bottom of the page, has concluded, no obligation for the state of origin to recognise or enforce such measures, which Hans van Loon says problematic and may be counterproductive. And at the second paragraph on the next page, the lack of provisions similar to Articles 7, 3 and 11 is a real gap. That lack is a real gap, may be illustrated by a recent judgment of the English High Court, and that's the case of B and B, a Lithuanian case, and there the court ordered a return but imposed pursuant to Article 11 conditions. The application of Article 11 seems incompatible with the Article 61 regulation. That's the priorities point. Yet this case brings out the advantages of Article 11. It enables the second indented passage, the Court of Refuge, to make itself at least initially adequate arrangements to secure the protection of the child after his or her return, without awaiting such measures to be taken by the Court of Origin, may encourage the Court of Origin to take such measures. And the next passage, in relation to protective measures taken under Article 20, the CJU's ruled that insofar as protection of the best interests of the child so requires, the courts, having taken the protective measures, must inform directly or through the central authority designated under Article 53, the central authority of the other state. That leads to collaboration. And then there are recommendations which allow, over the page, for a new article. And that new article is in exactly the same terms as Article 11. And one sees the words in bold after that, Article 20 to be deleted. Well, that isn't the outcome of the review, but it's the current state of thinking in that document from Hans van Loon. What it surely emphasises is that there is a clear distinction in the minds of those who are reviewing Article 20 between it and Article 17. Now,
I suppose you could say, well, he would say that, wouldn't he?
I could say it, but I wouldn't, my lady.
No, Mr. Turner might say that.
But someone might. But yes, but there it is. It doesn't just come from Hans van Loon. It comes in the context of his role in providing that advice to that directorate. What does actually happen remains to be seen.
5 more minutes, Mr. Settler.
I know. May I take a matter of seconds out of those to see what I ought to be dealing with?
It would be helpful to know what order you would want this court to make if we were with you.
The priorities point. Yeah. Right. And what is the order of receipt? All remitted. Yeah. Can I answer that the obvious question? If I don't say the easy question first. If the court is with us, we would like either an order for the return, or if the court is persuaded that justice requires a visiting of Mr. Turner's unsatisfied appeal points, a remitting to the Court of Appeal for that to be undertaken.
Isn't there another option as well? We would obviously have to take some view on Mr. Turner's unsatisfied appeal points, but another option would be to say, were we to be with you, yes, there is jurisdiction, but obviously it's a jurisdiction to determine what measures are necessary for the protection of the child. That's a first instance task, and it should go back to preferably Mr. Justice Wood, but otherwise another judge of the division, to decide what measures of protection are necessary, bearing in mind whatever we might say about the other points that Mr. Turner has to say about the process adopted before Mr. Justice Wood.
Yeah, and Mr. Deverex reminds me that that was the approach of the court in A&A when the matter went back not to the Court of Appeal but to Mrs. Justice Parker, who indeed duly resolved it. We would certainly support that, and no doubt Mr. Turner could run any relevant points before Mr. Justice Roderick Wood.
It would be for him to consider what protective measures are now necessary for the child.
Right.
Because it's a present situation.
Yes.
Right.
Precisely so. So, yes, we wouldn't remotely argue against that. What I have left is nothing in terms of time.
True.
But what I think I ought to do is to give the court the references in our written case to the way we deal with the priority point under Articles 61 and 62. We stand by those, even though I'm not going to have the chance to articulate and expand upon them. And it's MS 164 to 167, paragraphs 31 to 39. May I see if there's anything else from my two juniors or from the court? If not, then I should give way to Mr. Turner.
Thank you, Mr. Setright. But
Can I just ask one question?
well, Mr. Deverex has got a right to follow you on, whether to be anything more that he might want to say. Which would you prefer to ask the question of, my lord?
Mr. Deverex.
Happy to answer.
It's a point of information, Mr. Deverex. 1st November 2012, the 1996 convention becomes enforceable in this country. Is that date as between the UK and Morocco, or is it generally effective in the UK?
We deal with this in the written case, as far as I remember, but I think it is actually generally, depending on who's acceded to.
Because we looked at we've got the order, which is a 2010 order, saying that the 1996 convention is part of a EU treaty, which made me wonder, well, why are we talking about 2012 rather than 2010?
Well, there are a number of points that arise from that, which I'm not going to deal with, but I think the clear answer is that when we implement it, then it becomes a convention between those who have acceded to it. The oddity with the 96 convention is the way in which it was implemented, which is by virtue of the European piece of legislation. And I think Professor Lowe deals with that. It's hidden in the authorities'
Well, I couldn't easily find an answer to my question.
But he deals with it in the lecture that he gives.
It comes into force generally, and not just vis-à-vis Morocco, then that's good enough.
Thank you very much.
Thank you.
Yes, Mr. Turner.
Please, God, our understanding on that point was it came into force generally in the EC states and Morocco. I don't know about other countries because, as Mr. Devereux rightly says, it's come into force by the curious route not of being implemented via domestic legislation in the way the 1980 convention was, but being treated as an EU instrument.
Thank you.
We're bound by that now. At the heart of my submissions on behalf of the mother are two contentions which I'll develop to some extent, but which I've developed extensively already in our written case. And the first of those contentions is that the Court of Appeal was correct in its analysis of the jurisdiction to make orders for return of a child who's been wrongfully removed in a case in which the 1996 convention is engaged. And effectively, I submit that the answer to that question of what is the jurisdiction is insofar as there is any domestic jurisdiction under the Brussels II jurisprudence or otherwise, then the exercise of that jurisdiction is restricted or limited by virtue of Articles 7, 3 and 11 of the 96 Convention. Or alternatively, if there is no domestic jurisdiction which is alive in such cases, and one has to trawl through Brussels II and the 1986 Family Law Act in the way we did in the A&A case to discover whether there is such a domestic jurisdiction even on the face of it. But if there is such a jurisdiction on the face of it between England and Morocco, then, as I say, it's restricted. But if there is no such jurisdiction, then Articles 7.3, which applies Article 11 in a case of wrongful removal, themselves confer a jurisdiction on the English court. And it's important in my submission to look not simply at individual articles such as Article 11 of the 96 Convention as a freestanding or separate provision, but to look at it as part of the scheme that's been brought into force once the UK and Morocco became jointly part of the 1996 scheme. It must be looked at as a whole. Now, of course, as my lady rightly said, Article 11 can apply to any number of situations. And indeed, the examples that are given in the Lagarde report, examples that are given in the practical handbook, are all examples not of a return of a child as such, but they're the more obvious things such as urgent medical treatment required, or insofar as they're connected with wrongfully removed children, the supplementary power to add protective measures, measures which, recall, we can find in the Ray Eager case before this court, Mr. Setright had been explaining to the court would assist enormously if protective measures directed in this country could be enforced by some means in the receiving country. So one looks at it as a scheme, but bears in mind that that scheme, which includes Article 11 and the restrictive nature of Article 11, is specifically intended to be engaged in a wrongful removal case because it's specifically referred to in Article 7, which deals expressly with wrongful removal. So the draftsman clearly intended, in a case of wrongful removal, that whatever powers the court was exercising would be restricted in the way that any exercise of Article 11 is restricted by the words of that article. It's said by the commentators that it requires a restrictive construction because it derogates from the primary jurisdiction. One finds that in paragraph 68 of the Lagarde report.
But here, of course, the order that is sought doesn't derogate from the primary jurisdiction, it supplements it and enables it.
It supplements and enables it if the primary jurisdiction is exercised. And of course, one has also to bear in mind that frequently the two countries that are involved are both member states of the 1980 Convention as well as the 96 Convention. So in that situation, which is the more usual situation, the use of an order under Article 11 of the 96 Convention would certainly supplement in the way it did in the, I don't know if the court's had the opportunity to look yet at the Ray Y case, which was the first case where the 96 Convention received attention from the English courts. That was a case where an order for return to Cyprus had been made under the 1980 Convention. It was one where the mother was saying, I don't want to return because I'm scared of the situation that will confront me there on my return, running an Article 13B defence under the 1980 Convention. And the court imposed or extracted protective measures in the form of reassurances as to what the situation would be on the ground immediately upon return, and indeed concluded that because Cyprus and England were by then effective members of the 96 Convention community, that those measures would be effective and the court could be satisfied that there would be protection in place because the Cypriot courts would have to implement and enforce under Chapter 4 of the Convention. And of course, that's the other part of the scheme that one has to bear in mind. One has to bear in mind the whole scheme when one considers the submission that the important submission that Mr. Setright made towards the end of his oral case today, and which appears in his written case and in the written cases of certain others, which is that the approach adopted by the Court of Appeal here reduced the protection for children. Now, in my submission, it doesn't reduce the protection for children at all. Insofar as it removes one form of protection, if and insofar as the Ray J jurisprudence would have applied anyway, and I don't concede that it would have applied in this situation if one goes through the A&A test for jurisdiction, if and insofar as it removed that basis of jurisdiction, it replaced it instead with a new scheme whereby not only does the court of the country from which the abduction has taken place have jurisdiction which continues irrespective of any change in habitual residence. Article 7 means that there is that continuing extended jurisdiction until not only habitual residence has been changed, but the other conditions in Article 7 have been satisfied. So the primary court, the home court, has the power to make an order, and not only does it have the power to make an order, every other member state must implement and enforce that order with only the barest of exceptions, if I can call them the public policy exceptions. So in a sense, it can be seen on one view of things that the 1996 scheme actually strengthens the protection because it means that the Home Court, which should have decided the matter at the outset if things had gone properly, if the removing parent had gone to the Home Court and asked for permission, the Home Court is the dominant court to make the order, and the court of the country to which the child has gone doesn't have the sort of discretion that it has on a welfare basis under Ray J. It doesn't even have the 1980 exceptions. It has the much, much more restrictive obligation to enforce unless the public policy grounds are made out, which, as I say, is very much more exceptional. And we've referred in our printed case to certain authorities decided by Mr. Justice Mostyn in relation to cases where jurisdiction would exist between two countries, the members of the EU. Jurisdiction would exist to make an order for return under either the 1980 Hague Convention or to get an order from the Home Court and then enforce that order in England, in which case the exceptions to an order for enforcement would be much fewer, much more restricted than they would be under the 1980 Convention. And Mr. Justice Mostyn has held that it's most appropriate, if you can do it both ways, to do it under the Home Court order and the enforcement and implementation of the Home Court being the court of original habitual residence, which has been either continued as it is under Article 7 of the 96 Convention, or in a 1980 Hague case under Article 10, because there's a similar regime there. But what is important is the Article 10 of 1980, Article 10 of Brussels II revised, which supplements the 1980 Convention, does not have the restrictions which exist in relation to the 96 Convention. Because Article 10 of Brussels II retains jurisdiction to make orders for the Home Court, but it doesn't prevent other orders being made. There's no equivalent of Article 11, of Article 7.3 and Article 11. They're different schemes. And you can't mix and match in my submission between the schemes unless the respective countries are both members of each of the schemes that one is seeking to rely on. So here we say that if and insofar as there would ever have been jurisdiction for the English court to make an order on applying the Ray J principles, then that has now changed since November 2012 when the 1996 Convention came into force, and you have a different but comprehensive scheme where the emphasis is on the Home Court. Now, what then, and the second contention that I address, is the question of the way in which the Court of Appeal in the present case applied Articles 7.3 and 11 to the particular facts of the individual case. And the Court of Appeal made it absolutely clear that that's what it was doing, applying those words to the individual facts of the particular case. And I submit that one doesn't have to be concerned with the explanations of Lagarde et al. That the word should be applied restrictively because one is derogating from the primary jurisdiction, which given by Article 5 and continued by Article 7.1 of the 96 Convention. One just has to look at the natural meaning of the words of Article 7.3 and Article 11, and then look at them in the circumstances of the individual case. And as Lady Justice Black explained, in some situations, there may be a situation that justifies the making of an order by a court that isn't the court of primary jurisdiction, and in other situations, there may not. And on the particular facts of this case, the Court of Appeal decided there was not. Now, it can't be the case, can it, that in every single wrongful removal situation, no matter how long after the event an application is made to the English court, and no matter what opportunities there have been to make an application to the home court overseas, it will always be a matter which comes within Article 11. Now, when looking at Article 11, I accept immediately that protective measures has a wider meaning than one may have thought initially, and indeed Lady Justice Black herself pointed that out in paragraph 70 of the Court of Appeal judgment in Appendix 1, memory stick page 310, paragraph 70. And she referred there to Article 1, where protective measures first appears, and the definition, or the non-exclusive definition in Article 3. So she had that well in mind. And she nevertheless, supported by the other two members of the court, found that in the particular circumstance of this case, Article 11, and of course Article 7.3, which applies Article 11, specifically in wrongful removal or wrongful retention cases, wasn't satisfied. Now, of course, I accept that protection of a child can include the important necessity of a child having contact with both parents and with the families on both sides. Sadly, direct contact of that sort hasn't happened in this case, although the child has continued to have contact by electronic means with the father. I hope the court has or will in due course look at what I've said under the subheading in our written case of contact, because we acknowledge and accept that contact is crucially important, as indeed so did Lady Justice Black. And if we look at the latter part of paragraph 72 of her judgment in the Court of Appeal, that's memory stick page 311, what she said, well, turning back to the previous page, the father showed by his prior application to the Moroccan courts that a speedy application to the courts with jurisdiction under Article 5, that's the Home Court, and which maintains jurisdiction under Article 7, irrespective of any change in habitual residence, was entirely possible. So in the facts of this particular case, we know it's possible to make an application on speed because the father had done so. And there's been no explanation as to why he didn't apply in Morocco for a return order. I'll come back in a moment to the question of whether the Moroccan courts have the power to order a return, rather than a change of residence. I can see that in some cases the passage of time will make a measure of protection more urgent rather than less. Although what I interpose, one asks the question, well, can it really be said that it makes it more urgent and Article 11 applicable if the reason for the delay has been the left-behind parent doing absolutely nothing either in the Home Court or in the English court. But her ladyship goes on to say, but the facts will be very different from these, in my view. And then she adds this important point. What is potentially harmful to S here is not his living arrangements, but the fact that he is not keeping up his relationship with his father by direct contact. It's very important that that be remedied. Now, of course, important, necessary, urgent for the protection of the child, absolutely. And an application could have been made to achieve that, either by obtaining an order from Morocco and enforcing it in England by the enforcement route, or by coming to the English court and then saying, look, this is dragging on dreadfully. Please make an order under Article 11 because the need for face-to-face contact in the meantime, pending the conclusion of these proceedings, is important. What I invite the court to do when looking at Articles 7.3 and Article 11 of the 96 Convention is perhaps not to place the sole emphasis on the word urgency, as the Court of Appeal did. The phrases used in those two provisions, in my submission, have to be read as a whole. And perhaps a more important word in that phrase is necessary. How can it be said to be necessary to make an application to the subsidiary court when we know that the primary court under Article 5, continued by Article 7.1, could make an order which would in effect require the return of the child, an order which the English court would then be obliged to implement and enforce absent the restricted public policy grounds.
Which court is in a better position to make a temporary order that a child go back?
My Lord,
the Home Court doesn't have the child within it. The child has been unlawfully removed. The child isn't there.
But my Lord,
the difficulties about any sort of welfare analysis given to the Home Court are obvious.
My Lord, the fact is, however, that the Home Court, having made an order, is entitled to have it enforced by the away court, if I can call them the home and away court, without any consideration by the away court of welfare. Now, of course, under the Ray J jurisprudence, welfare is crucial. And that was the distinction between the Ray J position, where one's relying on wardship and the inherent jurisdiction, as compared with the 1980 Convention. And the court in Ray J was at pains to say, I think about 5 times, you can't treat the two schemes as the same. And at the heart of the Ray J scheme is welfare. So the English court would be obliged to conduct a welfare examination, which might conflict, in fact, with the conclusions by the Home Court. The Home Court is deliberately put in control, and the draftsman did not leave the let-out or alternatives that exist under the other schemes. Because under Brussels II revised, alternative routes can be adopted if the two countries can both be brought within them. Under the Hague Convention, the 1980 Hague Convention, there is specific provision in both the convention itself and in the act which enforces it, and in the rules which implement it, the family procedure rules, which we've identified in our written case, which actually make it clear that you can seek a return by any other route. You're not bound by the 1980 Hague case route. And indeed, that is why those various authorities that my learned friends refer to in paragraph 61 of their written case, the two Texan cases, the old case of Kay and the more recent case in this court, which again was from Texas, even though one wasn't able to rely for one reason or another on the Hague Convention to secure return, one was nevertheless able to rely upon a different domestic jurisdiction to implement a return. In none of those cases was the 96 Convention or the restrictions imposed by the 96 Convention involved.
You're inviting concentration on the word necessary. Are you saying that it means not merely necessary as a protection for the child, but necessary to be made by the away court as distinct from the home court?
I do, my lord. And by analogy, although I accept it's not a precise analogy because I rely on what was said by the Court of Appeal in the case of Vermouth and Vermouth. Under a different convention, under a different instrument, we've referred to it in our written case. But one of the points that was relied upon there was that an application could have been made to the overseas court. Now, in the present case, not only could an application have been made, an application was made, and the overseas court didn't make an order for return. Could the overseas court make an order for return? Nobody has specifically discovered that. That's right to say Mr. Justice Roderick Wood didn't permit cross-examining or questioning orally of the expert, although it's fair to him to say that this wasn't in the arena at the time, the jurisdictional point. So it's doubtful that that would have been raised in any event.
Well, it's quite extraordinary, isn't it? The set of questions that was asked did not include, could the Moroccan court, had it so desired, have made an order requiring your client to return the child?
Well, extraordinary with the benefit of hindsight now that the that the question of jurisdiction has been
slightly
raised.
Surprised that it wasn't asked,
I think
given the order that had been made.
I think the concentration at the time in relation to the expert was the question of relocation.
I know it was, yes, that's what most of the questions are about.
And indeed, that question of relocation is by no means as straightforward as Mr. Setright would have you believe, because one needs to look at Article 179 of the Moroccan Code, which clearly envisages only removal from Morocco for temporary purposes.
And indeed, it's not necessarily a weakness in your argument, but I think it follows from what you're saying that if your construction of necessary is right, circumstances in which an order could ever be made are going to be very, very rare indeed, because in almost all cases, the application in the English court is going to be met with, well, there's another convention state, it has its courts, it was capable of making this order.
No, I think one has to apply it a little more broadly than that, because one envisages that there are hot pursuit cases, and this case is anything but a hot pursuit case now, and it certainly wasn't a hot pursuit case even by the time it was in front of Mr. Justice Roderick Wood. There are certain hot pursuit cases where if you're going to return the child, and of course the whole essence of this is to reinstate the status quo ante as soon as possible, to put back in the situation as soon as it could have been done. So if it's discovered the child is here, and it can be shown that it would take some time to get on with an application in the overseas court rather than an immediate application, then in that sort of case, one envisages that the English court might well say, yes, this is a situation of urgency.
You'd have to show that there was a procedural obstacle and that you couldn't get before your home court with anything like in a reasonable time limit.
Yes, but of course what we do know here is not only was it possible to get before the Home Court in a reasonable time limit, but Mr. Justice Roderick Wood, as quoted by Lady Justice Black at the end of paragraph 26 of the Court of Appeal's judgment, memory stick page 300, said both parents would have access, this is what Mr. Justice Roderick Wood had said, both parents would have access to Moroccan lawyers and had litigated in Morocco already, where the litigation was dealt with swiftly.
Can I just ask you one completely separate question, because I see the time? I haven't personally got my head very much around your fallback position about the matters which went to the Court of Appeal but weren't dealt with. Is there anywhere in the papers an identification of what exactly were the questions you wanted to be able to ask an expert and weren't allowed to ask him? Because if there is, I'll do my homework over the break.
Lord, it was principally to do with the question of whether there was a relocation power. And the reason for that is Ray J makes clear that when one is exercising the Ray J welfare test, and is it in the child's welfare for there to be a summary return, one of the questions is, does the overseas court have the power to permit relocation?
To allow them to leave.
To allow them to leave, exactly.
So the question which you say you were wrongly not allowed to ask the expert was, does the Moroccan court have the power to permit overseas relocation?
Yes. That was the principal matter. I'll check whether there was anything else, because, of course, it was Miss Moore who was dealing with that. But we say that that was one of the matters, the substantive matters, on which Mr. Justice Roderick Wood was either clearly wrong or arguably wrong, and at the very least the expert should have been asked questions to clarify.
Among the various possible ways that this case might go, if it were to go back to Mr. Justice Roderick Wood, you would, I imagine, have time to get an expert's report on that very point if you wanted to.
Oh, absolutely.
And ask him to look at it.
If the case goes back to, and I certainly see the force, if the case goes back, of it going back to first instance, and I think that, of course, was what happened in the LC case as well. It was remitted to first instance. Whether it should be Mr. Justice Roderick Wood or not is another question, but I won't address the court on that now. Shall I, when we come back, deal with the question of the power for the Moroccan court to make an order for return, if I try to remember to start with that?
Yes. Thank you very much indeed. We will adjourn now and look forward to hearing from you further at 2:00.